Just ask, no, that we are on the hill. They are on Fansipim School. That's my reaction to whatever this.
I'm sure you're waiting for my next reaction. And my next reaction is to honor our long-held tradition that Sepein Gwara Nensuasa. So there is nothing else to say. Nana, thank you very much. So, among the 17 justice clubs that were inaugurated across the western and central regions, we have two of them over here, one from Edinaman and then the other Wesley Girls High School. There will be a skit by Wesley Girls High School, but to be preceded by a skit by our brethren from Edinaman Senior High.
Oye, listen, oh, listen, oh, listen.
One day, oh, one day, oh, one day. Supreme Court is 150 years. Hooray! Yes, in 1876, July 24. Common law, doctrine of equity, and the status of general application, which were enforced in England, be enforced within a jurisdiction. Legal system was soon.
Supreme Court by British decree. Gold Coast soil, yet laws not our own. Justice spoke with the foreign key. In 1957, the motion of destiny was tabled. Order in council promulgated. The dawn broke free. The black star raised high. The court of God in 1966, 1979 by the Armed Force Revolutionary Council, and in 1981 by the Provincial National Defense Council.
The Fourth Republic gave its birth anew. 1992 Constitution,
It's showed and sold.
supreme in matters,
The framers drew.
guardian of right.
The people's accord.
It drew a line where power went too far. In the case Chachuchi Kata versus the Attorney General, it made power pause. In the case New Patriotic Party versus the Attorney General, it protected the ballots.
The voice
Gavel in hand, and Bar Association versus and be free.
from colonial bench to constitutional throne. The Supreme Court stands. Neither gold nor crown. Not perfect, not powerless, but our own, to weigh the state by separation of powers and keep tyrants down by rule of law. Rule of law isn't marble, it's a and the weak can
Court.
report 523. The
Of shall and should in the Article 13 of the 1960 Constitution. It finally taught us that when parliaments give executive power to act outside the court, it often causes a blow to judicial independence. It's a moment the court bowed to the parliament, the Supreme Court as the custodian of our rights and liberty as people. Supreme Court,
Ayiko.
Supreme Court, Mwone Juma. Long live Ghana, long live rule of law, long live Supreme Court. Thank you.
Please, we can do it better. We can do it better. Whilst we invite Wesley Girls High School.
safety and peace. Unfortunately for Anna and her daughter Jane, home has become a place of fear. This is a moot court drama on assault titled Behind Closed Doors.
Kojo, I'm so tired of this man. Kojo, you come home and start complaining about food. Food I just put on fire for like 1 minute. Like this. I'm so tired of you. He's always beating me like I'm some punching bag. Hey, better do your homework, eh? Your father will come and throw you somewhere. You know how that man is. Please.
Anna, where's your stupid wife?
Anna, where are you? Kojo,
Where's my food?
Kojo, please give me 5 minutes. Just 5 minutes.
Everything,
5 minutes. Kojo,
why?
Kojo, please.
Every day, 5 minutes, why? Every day, 5 minutes, why? 5 minutes, and why? Mind your business. Mind your business, she's my wife. Go home and take care of your children. Mind your business. Mind your business.
Anna, this cannot continue.
Moving
He
outside
apologizes
the house.
every time.
Your daughter is suffering too.
I don't know what to do again. I'm just tired of this man.
Assault is a crime. You deserve protection. See how you are suffering, Anna.
Anna, go to the police and let the court help you.
He'll get angry if I send him there.
I will get scared when daddy comes home. Oh, justice exists to protect victims, not to punish them for seeking help. Oh my God, what's wrong with you?
All over my body, ask me out. Ouch.
The police gather evidence and charge Kojo with assault.
Case number 001/2026, Republic versus Kwejo Mensah. Are counsels ready? Accused, I will now read your charges to you. Please listen attentively. Mr. Kwejo Mensah, on the 28th of June 2026 at Pedu, Cape Coast Central Region, you were found hitting your wife repeatedly and stepping on her stomach, leading to profuse bleeding and loss of her pregnancy. Are you guilty or not? I repeat, are you guilty or not? My lady, with respect, accused pleased not guilty.
My lady, the accused is innocent until proven guilty by this court. He has a permanent place of abode and a credible person to stand as surety. If he is granted bail, he is going to reappear to stand trial.
Accused. Therefore, the application is refused. Let's proceed.
My lady, Today we shall prove that the accused repeatedly assaulted his wife in the presence of their child.
Going to swear with the Bible, cross, or a Quran. Repeat after me. I,
Mrs. Anna Mensah,
do swear by this Bible
do swear by this Bible
that I shall speak the truth
that I shall speak the truth
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
My lady, with respect, SOB in English.
Mention your name to the court.
Please, I am Mrs. Anna Mensah.
And where do you live?
Pedu.
What do you do for a living?
On weekdays, I sell bread, and on weekends, I fry and sell.
Have you given your witness statement to your lawyers?
Yes, I have.
Check whether this is your witness statement and your signature. Respectfully, my lady, I wish to tender the witness statement and the various exhibits attached as a evidence in chief.
Any cross-examination?
Mrs. Anna Mensah, did my client not provide you with food and shelter?
Yes, he did.
Were there any circumstances where he remained unfaithful to you?
No, not really.
Did he?
My lady, respectfully,
Objection sustained. Examination?
No, my lady.
Witness, you are discharged.
The prosecution calls its second witness in the person of Ms. Jane Mensah.
Are you going to swear with the Bible, Quran, or cross?
The court what your name is.
Please, I'm Jane Mensah.
And where do you reside?
Pedu.
What do you do for a living?
Please, I'm a student of Wesley Girls High School.
And have you handed over your witness statement to your lawyers?
Yes, I have.
Check whether this is your witness statement and your signature.
Please, this is it.
Respectfully, my lady, I wish to tender the witness statement and the various exhibits attached as a evidence in chief.
Any cross-examination?
Jane Mensah, were you there when the alleged offense took place?
Yes, I was.
On which day did the alleged offense take place?
Saturday, 28th June.
Well, I put it to you that the alleged misunderstanding took place on a Monday, not on a Sunday, as you alleged. That will be all for the witness, my lady.
Any re-examination? Witness, you are discharged.
Are you going to swear with the Bible, Quran, or cross?
I, Dr. Mustafi Salif, do swear by this Quran that I shall speak the truth and nothing but the truth. So may Allah help me.
My lady, with respect, SOKO in English.
Kindly mention your name to the court.
I am Dr. Mustafia Salif,
And where is your place of abode?
Kakumdo.
What's your occupation?
I'm a medical doctor at St. Anne's Hospital.
Have you given your witness statement to your lawyers?
Yes.
Kindly check whether this is your witness statement and your signature. My lady, with respect, I wish to tender the witness statement and the various exhibits attached as a evidence in chief.
Any cross-examination?
Dr. Salif,
Yes, please.
how long have you been working in that facility?
Please, I've been working there for 10 years.
When did you examine the accused person?
I examined the victim on the 28th of June.
Well, I put it to you that set date you just mentioned, you were out of the country and could not examine the victim.
With respect, my lady, I examined the victim on the said date.
That will be all for the witness, my lady.
Any re-examination? Witness, you are discharged.
Thank you, my lady.
My lady, the prosecution calls on its fourth and final witness in the person of Miss Nicole Brown.
Are you going to swear with the Bible, Quran, or cross?
I, Nicole Brown, do swear by this Bible that I shall speak the truth and nothing but the truth. So help me God.
My lady, with respect, SOB in English.
I am Miss Nicole Brown, Abra. I am a social welfare officer. I have. This is it.
Any cross-examination?
Miss Nicole Brown, please, how long have you been working as a social welfare officer?
I've been working for 10 years.
What exactly do you do as a social welfare officer?
I write reports on children to be adopted, as well as families who want to do adoptions, how their homes are maintained, and how individuals in their homes behave to institutions who may need them.
In respect to children, what exactly do you do?
We examine children who suffer domestic violence. Children who repeatedly witness domestic violence often suffer fear, anxiety, poor academic performance, and emotional distress. This child's welfare is at risk.
That will be all for the witness, my lady.
Any re-examination? Witness, you are discharged.
Thank you, my lady.
The judge found a prima facie case against the accused person. She then asked the accused person to open her defense. The accused person gave his evidence and was cross-examined. He then closed the case.
After considering the evidence before this honorable court, I find that the prosecution has proved its case beyond reasonable doubt. This court notes that repeated violence has caused physical harm to the wife and emotional harm to the child. Marriage is built on love, respect, and dignity, not fear. Accordingly, the accused is sentenced according to the law. What do you have to say, counsel for the accused?
My lady, the accused regrets his actions. He asks for mercy and promises to seek counseling and change his behavior.
My lady, assault in a domestic setting has become rampant, as we have proven the accused has assaulted the victim severally and has gone unpunished. So I pray the accused is punished severely.
I hereby sentence Mr. Kojo Mensah to the term of 2 years in prison to be served at the Ankerful Prison Annex. He shall undergo mandatory anger management and counseling. A protection order is granted to Anna. The Department of Social Welfare shall provide counseling and support for Jane. The police shall monitor this compliance with order. Let this serve as a reminder that silence protects abuse, but justice protects families. This court is adjourned.
Domestic violence is not a private family matter. It's a violation of human rights. Say no to domestic violence. Speak up, seek help, protect children. Let justice prevail. For injustice anywhere is a threat to justice everywhere. Thank you.
Well, let's continue to appreciate them. Very well acted out. Prof. Chair, my lords, I heard a few colleagues indicating that they will go on appeal. And I'm sure by the time the next lecture comes up, either in Kumasi or in Accra, it would have been duly filed. Thank you very much, Wesley Girls High School. Prof. Chair, there is a Latin phrase that sits at the heart of every judicial tradition. Ubi ius, ibi remedium. That is, where there is a right, there is a remedy. For 150 years, the Supreme Court of Ghana has provided an answer to that in practice. Our keynote speaker has spent a distinguished career asking and also answering what that promise means in practice. I invite a private legal practitioner and an assistant lecturer at the Faculty of Law, University of Cape Coast, Mr. Alexander Hackman Adu, to introduce our keynote speaker.
Prof. Chair, my lords, ladies and gentlemen, may I, with respect, also associate myself with the existing protocol. It is a distinguished honor, or distinct honor, to be asked to introduce the keynote speaker for the first in the series of lectures to commemorate the 158th anniversary of the Supreme Court of Ghana. Professor Philip Ebobonze Simpson is a professor of law with the University of Cape Coast and the managing solicitor of the Upper Chamber, Peps Court, Cape Coast. He's a former rector of the Ghana Institute of Management and Public Administration. He's also the first vice chancellor of the Methodist University, Ghana, the founding dean of the Faculty of Law, University of Cape Coast, a former dean of the School of Business, University of Cape Coast, a former director of Legal Services and Investigations at the Commission on Human Rights and Administrative Justice, a former chairman of the Committee on Legal Education and Professional Development of the Ghana Bar Association, a former member of the General Legal Council, a scholar in judicial studies. He was the research consultant of the Judicial Service who conducted the baseline survey of courts in the Central Region, which report was presented at the annual Chief Justices Forum held at Elmina on 1st December 2009. The facilitator and general rapporteur of the Chief Justices Forum on Integrity in the Judicial Service held at Accra on 14th November 2014, and the researcher commissioned by the Judicial Service to undertake the study on the feasibility of establishing mobile courts in the Republic of Ghana in September 2016. He's a former council member of the Judicial Training Institute. He's married to Professor Mrs. Alberta Bonze Simpson, and he has 5 children. Ladies and gentlemen, with a round of applause, shall we receive our keynote speaker for today's lecture.
Whilst the computer is booting up, let me also commence by associating myself with the established protocols. Having said that, there are some key personalities in the protocol list that I'd like to mention. The Vice Chancellor of the University of Cape Coast and the Chairman for the occasion, His Lordship, the Chief Justice being represented by His Lordship, Justice Gabriel Scott Boamang. We go back a long way to the early 80s when we were both young men and law students and in the Commonwealth Hall. We were good boys and we remain good. I recognize, therefore, all justices of the Supreme Court, of the Court of Appeal, of the High Court. Let me particularly also mention the chair of the Planning Committee for this occasion. I recognize you. Saberima Kwisata the second, doctor, landlord, we appreciate you. This is a university, while acknowledging the professors present, the members of convocation present, let me particularly also mention the students. And I've appreciated the skit and the poem by the Justice Claps, I do not have the authority to make any commitments on behalf of the university, but perhaps with the permission of the Vice Chancellor, should any of these persons who presented today apply to the Faculty of Law over here and get the appropriate grades, perhaps even a point or two above the cutoff, special consideration and dispensation should be extended to them. I hope this prayer will be granted, and no one will say by what authority, who, whereunto. It's my singular honor and privilege to accept to be here this morning. It's now afternoon. If it were left to me, I would have negotiated the time, because it has coincided with the World Cup season. But a request to participate in this is first and foremost an honor, a singular honor, and I'm humbled by it. But also noting where it is coming from, it is a summons to be present. Because if you get an invitation from the Judicial Service and you don't honor it, bench warrant will issue. Yesterday, I laxed a little bit because there were two matches I was watching. There was one which featured Democratic Republic of Congo. There was another one which featured Senegal. And as I was watching them, my wife, who often calls me words of endearment, reminded me that I have another name. She asked, "Are you not a professor?" And I wondered why. If you are a professor and you have a lecture for tomorrow, what are you doing watching football? I am under authority. So I had to spend time on this exercise. I'm mindful of the time now, and so I do not intend to go through all of the slides that I have over here. I will focus on certain aspects. I have selected the title of my presentation deliberately, keeping in mind the theme and the topic. We are commemorating 150 years of the judicial service in a certain way. And in that commemoration, as a number of speakers have said, we are honoring the past. So my presentation will endeavor to look at where we have come from. We are celebrating the present. The presentation will endeavor to look at where we are and what is right and what can be improved. And we will be called upon to define the future. So I'll endeavor to make a comment or two, hopefully with a view to improve upon where we are. The topic reflects on what Cape Coast has done, and especially in the context of the framing or development of the legal architecture. For this reason, taking into account the theme and the topic, permit me, Mr. Chairman, to speak to the trajectory of Ghana's judicial architecture over the sesquicentenary. That is from 1876 to 2026. I will highlight the following. I'll make some preliminary comments. I will then focus on 6 thematic areas. I'll spend a little bit of time on that. Then I'll make some observations and recommendations. The presentation itself goes way beyond that, and so there will be some slides I will show, but not necessarily project. If the IT team can be here to help me with moving the slides along. Preliminary comments. 1, even though we are talking about an 1876 ordinance, it is important to state that there was an 1853 ordinance. And even before the 1853 ordinance, there were courts that operated in this country. Traditional courts, as well as courts of the European model. It's important to stress these things because we may have the tendency of thinking that the contemporary judicial structure started in 1866. It was not indeed the case. Prior to this 1876 ordinance, let us recall that the European presence in our parts was from about the 15th century. The Danes, the Dutch, the Swiss, and the English were all here after the Portuguese had started the first trip. There was once a George MacLean, and around the time the governor, which was the political establishment, was separate but closely associated with the trading establishment. So there was a committee or council of merchants. Within the forts and castles, there was some judicial order. Beyond the forts and castles, the traditional authorities operated in a certain way, and the European establishment sought to also extend beyond that. So the Committee of Merchants introduced justices of the peace. Later on, they introduced judicial assessors. The judicial assessors were persons who were therefore operating beyond the forts and castles. So let us recall that we had these. Then we had the bond of 1844. Indeed, that bond is dated the 6th of March, 1844, and the selection of the 6th of March, 1957 was deliberate, so as to commemorate formally the break from the subjection to British jurisdiction over us. By the bond of 1844, there was a private treaty between some Fanti chiefs and the colonial, in this case, the British authorities, to extend authority there and to prevent various practices, some described as barbaric. Then you had the 1850 arrangements with the assessors, the most common ones after the MacLean era, were Cruikshank, Bannerman, and Fitzpatrick. Fitzpatrick came in 1850 the ordinance, first Supreme Court ordinance, it must be said, the first Supreme Court ordinance was 1853, not 1876. The 1853 ordinance therefore preceded the 1876, but we didn't have Ghana or the Gold Coast as a colony. The Gold Coast was handled together with Sierra Leone and parts of Lagos. Not called British West Africa, but the Gold Coast until the 24th of July, 1874, was run together with Sierra Leone. So the 1853 ordinance preceded the 1876 ordinance, and it is when the Gold Coast became a colony in 1874 that subsequent legislation in 1876 ordinance was established. So I have made mention of the judicial assessors. There were existing assessors, and so Fitzpatrick was an assessor handling matters of the merchants amongst themselves and in their dealings with the natives, and some recognized matters for which the natives brought to their courts. And with the passage of the 1853 ordinance, the first Chief Justice was the judicial assessor and Chief Justice. When he handled matters outside the forts and castles, he was an assessor. When he handled matters for the forts and castles, he was a Chief Justice. And so that was the dispensation then. We are commemorating 150 years of the contemporary legal order, but it is not the same as a commemoration of the establishment of the legal profession. The legal profession preceded that. The third observation I want to make is that whilst the court that was established in 1853, which didn't last too long, and in 1876, for which we had today, was called the Supreme Court, it is not the same as the current Supreme Court. Indeed, that court was the equivalent of a high court, not of the Supreme Court. It was not an apex court, but it was the equivalent of a high court, and it had the powers and jurisdiction of the high court except for admiralty matters. Therefore, if we are talking about the Supreme Court today and the number of courts in the judicial structure which have endured the most, looking at the provisions of the Supreme Court Ordinance of 1876, we are looking at two courts in particular. The most enduring courts, therefore, have been the current High Court, then called Supreme Court, and the current District Court. Another preliminary point that I wish to make is that prior to the establishment of the Gold Coast as a colony, I've made that point before, we were jointly administered with Sierra Leone. But subsequent to that, after 1874, when the colony was established, the current Ghana has had jurisdictions added to it and has dealt with the colony. There was a Gold Coast colony. Then, in 1901, to annexation of Ashanti. The second thing which happened was making the Northern Territories a protectorate. So Gold Coast had the colony, Ashanti, and the Northern Territories. The significant parts of contemporary Oti region and Volta region, not the entirety of it, was originally German. And after the First World War and the Germans having been vanquished, that part came controlled under the UN trusteeship, the League of Nations mandate system. Then the Second World War, that same part became controlled under the UN trusteeship system. And getting to the eve of our independence, there was a plebiscite which brought in the Transvolta Togoland. So we therefore have the jurisdiction of our courts, including the High Court and current Supreme Court, coming together, in a sense, in piecemeal over these periods. As has been said before, the capital moved in 1877 to Accra. So from about the 15th century, with the operations of the forts and castles and the different merchants that we had over there, through to ordinance was established, you can see the periodic progression of the court system. It is important, therefore, to stress that when we assumed the jurisdiction of the Gold Coast Supreme Court, which is the High Court, the ordinance therefore stated that it had incorporated the chief magistrates of the settlement of the Gold Coast, so it meant that those courts were there already, the chief magistrates of the settlement of Lagos, the assessors to native courts, the civil commandants we spoke about, and the magistracy that we had over here. I will just mention something briefly about the Supreme Court ordinance itself. One point that I've maintained, Gold Coast split from Sierra Leone. Lagos was part of it. So in 1876, the jurisdiction of the Supreme Court included the area of Lagos. As we are celebrating our 150 years, we should also look back and remember that our brothers and sisters from Sierra Leone are part of the celebration, and our brothers and sisters from Lagos in particular, and not the entirety of Nigeria, are part of the celebration. I've mentioned this before. It's called Supreme Court. We've got a current Supreme Court, but the jurisdiction set out by the ordinance indicated that High Court, except for Admiralty matters. The High Court did a number of things. It was structured in a number of ways, and I will be speaking about some of these things in a moment. Supreme Court. The Supreme Court in 1876 was essentially a trial court, but it had some appellate jurisdictions. In terms of structure, there were three dimensions to it. There was the full court, there was the divisional court, and there was the special divisional court. The Supreme Court itself was composed of a Chief Justice, then the Chief Justice for Nigeria, then the Chief Justice for Sierra Leone, and at least two puisne judges. It's spelled P-U-I-S-N-E, but it is not pronounced puisne. It's pronounced puisne. So when you have the divisional court, what it actually meant was that as the Gold Coast was then divided into provinces or districts, You had the Eastern Province, you had the Central Province, you had the Western Province, and the like. The district that a judge was posted to had the full powers of the Supreme Court. And the High Court judge for that district, or the puny court for that district, is what constituted the divisional court. When two divisions came together, or a certain matter had to be considered by the puny justices of two of the divisions, it was a special divisional court. And when the entirety of the court composed itself to hear a matter, it was the full court. The other court, so three divisions of the Supreme Court, which is a high court, and then there was the District Commissioners Court. The District Commissioners Court, which later on is the equivalent of the District Court, was then not manned by a judge or magistrate exclusively assigned to that role. It was the political head. So the district commissioner was the district magistrate, or a person designated by the district commissioner or the governor. And therefore, district commissioners are traditionally referred to, and it's the same for current dispensation, district chief executive, your worship. And the same goes for district magistrates, your worship. So during that period, under the district courts, you tended to find various appointments of a certain nature. And with the fusing of judicial, administrative, and political authority in one person, it created a lot of problems. Let me skip this slide about the structure of the 1876 ordinance, except to say that that ordinance was a precursor to many things. The 1876 ordinance was very voluminous, over 160 pages with its annexures. That ordinance served as the Courts Act. It served as the Legal Profession Act. It served as the Evidence Act. It served as the Rules of Court and more. So in subsequent dispensations, portions of these were hived off for separate pieces of legislation. But the 1876 ordinance was extensive. Amongst the officers of the court that it listed was a group whose terminology is not used now. Amongst the officers of the court was a group called messengers. The role and function of messengers was to serve processes appointed by the sheriff, and the sheriff was the equivalent of the IGP. It was the Inspector General of the Royal Gold Coast Constabulary. So that person appointed an officer to maintain order in the court, and the sheriff therefore appointed these messengers to serve the court. And when they were not serving processes, they maintained order in court. Subsequent amendments to the original Supreme Court ordinance changed the name of messengers to bailiffs. So that is the origin of that. We'll see this over here. I will skip the 1935 ordinance. So we had the 1853 Supreme Court ordinance. We had the 1876 ordinance, which had a good number of amendments to it. And then in 1935, the name of the ordinance and its structure changed. 53 and 76, it's Supreme Court. By the time we got to 1935, it was changed to the Courts Ordinance. It was no longer the Supreme Court Ordinance. Then that was a precursor to subsequent Courts Acts and amendments to the Courts Acts. Even the 1935 Ordinance maintained the Supreme Court and treated it as a high court with the different structures to it, and it added the land court. Then there were the magistrate courts, and the magistrate courts included the courts that handled matters pertaining to juveniles, persons under 16 years old. And for persons under 16 years old, under the 1935 Ordinance, it mandated the juvenile court constituted by the district magistrate or a chair and 2 other persons to hold parents of errant juveniles responsible and accountable in damages and in fines for the ways of their children and wards, unless they could demonstrate that they knew nothing about it or they did everything that they could, and the child ought to suffer his or her own penalty themselves. So we had the Supreme Court with the different dimensions to it, the magistracy, and then you had the District Commissioners Court, which was no different from the rest. I will spend time going through the 115 years, and I use the word in courts abroad appeals, and this is the period for which the West African Court of Appeal and the Privy Council in particular were active in their operations. The third that I'll speak to is about customary law, native courts, and chieftaincy. Then we come to a fourth thematic area, which is the decolonizing of the court structure. Up to 1957, we were under colonial rule. How did we shake ourselves of the shackles, and how did it manifest itself in legislation and in practice? Finally, or penultimately, we will be looking at the influence of the military on our judicial structure. And this they have done in a number of ways. Sometimes by the courts that they have not allowed to function. Some of our previous speakers have drawn attention to the fact that when revolutionary and military dispensations enter, certain courts are abolished. But the other thing that has taken place during this period is that a certain military and or revolutionary flavor has influenced the composition of our court structure, some of which pertains to date. And the final thematic area is the neutralization of these. In respect of the entrenchment, suffice it to say that prior to 1876, we had different courts of the European ilk. These were roped into the ordinance, and then from that point in time, the officially established courts were the Supreme Court with its different divisions, the magistracy. I should say at this time, native courts were not part of it. Native courts were recognized. You can go and do your thing, and even in the European court system, if you come there, we will apply native law subject to the repugnancy clause. So native courts were not recognized. Native law was allowed subject to the repugnancy clause. Having done that, then there's a second phase of appeals to court abroad. The Privy Council was established in 1933. It was established abroad. The British influence in the Caribbean, in North America, including Canada, in several parts of Africa, including British West Africa, British East Africa, British Southern Africa, and the Far East. So because of that, they had forts, castles, possessions, dominions, and appeals were allowed all the way since 1833. So by the time that the Supreme Court Ordinance of 1876 came, the Privy Council was already in situ. And in special cases, leave was granted for further appeals to go there. The West African Court of Appeal, WACA, had its origins later than the Privy Council. It operated for a certain period until 1874, and it became moribund. But around the 1920s, when the National Congress for British West Africa became very active, the likes of Hutton Mills and Casely Hayford, etc., became very active. They made moves for the re-establishment of that court, and the West African Court of Appeal got resuscitated and became active in the 1820s to the 1830s. However, after that period, it remained on our books and some cases were still going, and it remained the WACA, it remained part of the judicial dispensation until 1957. So even though the operation of that court had its peak point, it has been part of a structure until the 1957 Constitution abolished it. So we've got to the period when the courts had appeals to WACA. They may sometimes end there, or further appeals to the Privy Council. The Privy Council, we call it Privy Council generally, but it's actually the Judicial Committee of the Privy Council, because the Privy Council did all kinds of things. It set up policy, it provided advice to royalty, it heard cases, so it's the Judicial Committee of the Privy Council. So we've dealt with the entrenchment of the colonial courts. We have dealt with the period when the courts, when appeals were going to courts abroad, and in particular to the West African Court of Appeal and to the Privy Council. The third thematic area we are going to be looking at is customary law. But they have not always been part of the formal structure. It indeed, while it was recognized, and so if you had a plaint and you were a certain area, you could go to your traditional area, invoke an oath, pay some amount of money, cash, or give sheep, eggs, or chicken, then the process will begin. If those things happen and you are not too satisfied, you can then appeal to the district courts, the magistracy, and they will then hear it. So native courts were there. Native law was applied. They were not part of our structure. It was not much later till the 1940s that there were a plethora of legislation now recognizing and incorporating native courts into the judicial structure. So that was only in the end, so we'll come to some of those pieces of legislation. Even as we have it now, except for the judicial committees of the houses of chiefs, you don't have a proper court system recognized by the Constitution or the Courts Act for native courts. So it must be understood that we value the traditional mechanisms of dispute settlement. The Constitution recognizes customary law as part of the common law of Ghana, which is up to the superior courts to interpret, to mean and reflect its content. As far as the houses of chiefs are concerned, following the recognition of the courts, the recognition of customary law, the appreciation of their role, and in the spirit of indirect rule from Lord Lugard's time, it was kind of a live and let's live situation. The colonial authorities found it convenient not to rock the boat, but they also didn't want to grant too much powers to them for them to disturb the system. Even with the establishment of the Supreme Court in 1876, it was not till 1925 that the first Ghanaian, Bannerman, Woolworth Bannerman, was appointed a puisne judge. So all along, the mindset of the colonial authorities was, okay, let's countenance them, let's give them space, but let's not give them too much space because they can be problematic. Even the educated Africans, they can be problematic. If you appoint natives, even the lawyers to the bench, you don't know what they will do. So they studied the natives from 1874 to 1925, then they said, let's try one and see. That is also what they did. But the attitude of the colonial authorities in respect of chieftaincy unfortunately became the same attitude of the Ghanaian politician when they assumed power. So we have the native law, you have the native institutions. Then in 1960, the Chieftaincy Act is passed. Recognized chiefs, establishes houses of chiefs, but says two telling things. The recognition and derecognition of a chief was a political matter. And the second thing that happened was that even when the Judicial Committee of a House of Chiefs has determined the matter, it could be varied as the minister responsible for chieftaincy deemed fit. So you will have the 1960 Constitution, which has provision for chieftaincy. It has provision for chieftaincy institutions, but the control goes beyond them. Then there was the 1969 Constitution, which came for the Second Republic. And whereas the First Republic made provisions for the institution of chieftaincy, it limited it to the regional houses of chiefs. For the Second Republic, it established the National House of Chiefs, made even provision for a chieftaincy tribunal. But the composition of the houses of chiefs were select numbers, 5 from the regions. And the Third Republican Constitution, and it's about the same thing with the Fourth Republican Constitution, went a step further, and it created these houses of chiefs, traditional council, the Judicial Committee, Regional House of Chiefs, then the National House of Chiefs. But you will see that even for the Third and for the Fourth Republic, which had these ones, all along the adjudicating authority of chiefs was not vested in them. The adjudication of chieftaincy matters, however, were exclusive to these judicial committees, and of course supervisory jurisdiction existed over them, and further appeals from the National House of Chiefs could go to the Supreme Court. let me just project very briefly a number of the slides, a number of the ordinances that related to chieftaincy around this period. So we've dealt with some of the thematic areas relating to the Supreme Court itself, to appeals to courts abroad, to the application of customary law, the operation of native courts, and how the chieftaincy institution functions. The next thematic area I briefly want to address is the decolonization of the judiciary. So we've come to the eve of independence, and then we have come to the day of independence, and we have come to the day after independence. The 1960 Constitution, as I said before, it abolished the West African Court of Appeal. Interestingly, the 1957 Constitution, by which we gained our independence, was on order in council, maintained federal appeals to the Privy Council. And maybe it can be understandable because we became, in effect, a dominion. So we had a governor or governor general, the Queen was a head of state, and further appeals went to the Privy Council. But by 1960, we had now become a republic. And Osajifo said, with a republic, not only is the waka going on paper, but the Privy Council is also going on paper and in fact. So the 1960 Constitution abolished the Privy Council. That's the Judicial Committee of the Privy Council. And the 1960 Constitution introduced a two-tier superior court structure. Under the previous dispensations of the ordinance, there was a one-tier superior court structure. It was high court only, but it was divided in ways that it could sit as full court, high court, special divisional court, high court, or divisional court, high court. With the 1960 Constitution, we got a two-tier superior court structure, which is you have the high court, so now the previous Supreme Court is now called High Court. And then you have something called Supreme Court. Same name, different jurisdiction, different status. So under the 1960 Constitution, you have a two-tier Supreme Court. The Supreme Court, which is the apex court, final appellate court, and exercising constitutional interpretation jurisdiction. Then you have the High Court. The Constitution anticipated and made provision for the Court of Appeal, but it did not establish it. So under the 1960 Constitution, you do not have a Court of Appeal, but in the letters, you see it. Because even for qualifications to the Supreme Court, etc., you had to be qualified to the Court of Appeal. So you have two-tier Superior Court. Scenario 1, High Court and Supreme Court. Scenario 2, still two-tier Supreme Court, High Court and Court of Appeal. High Court and Court of Appeal because in between, when you come to the 1969 and 79 and 92 constitutions, there was provision for High Court, Court of Appeal, and Supreme Court. So now you've got 3 tiers of Superior Court. High Court alone called Supreme Court, High Court and Supreme Court, and then High Court and Court of Appeal. And the High Court and Court of Appeal applies when there's a constitutional dispensation, particularly for the NLC and the NRC. You have them abolishing the previous constitutions. The same happened where there was a slight variation in its delivery for the Third Republic. So the decolonization process of the 60s took the form of the total elimination of WACA and Privy Council, one. It took the form of establishing the Supreme Court proper, and then it took the form of enacting a Courts Act, which set out in detail composition, functions, powers, and the like. Then around the same period, as part of the decolonization purpose, there was the enactment of the Legal Profession Act. So these are 4 stages we have looked at, covering a significant chunk of 150 years. We now come to another, the influence of the military and revolution. This started with Acheampong, and it was entrenched by Rawlings. When Acheampong came following the overthrow of the Second Republic and the establishment of the NLC, he was concerned with a number of things, including security and economic crimes. His fear of the security matters caused him never to travel except once to Togo by road in 75 to go and participate in the Treaty of Lagos commissioning. Those who were around will recall the word subversion. So a subversion decree was passed, and it dealt with the destabilization of the country. The subversion decree also, which had its economic dimension, said, if you go and cut electric wire, you go and smuggle cocoa, steal cocoa, cola nut, timber, natural resources, pharmaceuticals, and the like, you have committed subversion. And they established military tribunals. For the offense of subversion, maximum penalty was a capital. Shot by firing squad. Certain penalties that they could impose were 15 to 30 years imprisonment. So, and it was not, the special military tribunals were different from the existing, court-martials, general court-martial, court-martial appeals, and so on. So the military courts which Acheampong established, which dealt with subversion, which covered a lot of the contemporary offenses of economic crimes, and some of those under the Mines, Minerals and Minings Act were covered there. And it extended its jurisdiction to civilians. So that was the first introduction of that type of military tribunal into the general court system to apply to civilians. Come June 4th, short period from June to September, there were a lot of things yesterday, or was it the day before, was Martyrs' Day. And we recall some of the things that some of the judges who were martyred dealt with as a result of that blitz. The revolution, AFRC introduced tribunals of a different character. You had the special courts in 79, and under that, the generals were tried. Then when 2 years later, the revolution, PNDC, the PNDC came, they introduced national tribunals, public tribunals at the national level, regional level, district level, and community level. When the PNDC was about leaving and the Fourth Republic was being ushered into it, provisions about the tribunals were introduced into the Constitution. The Constitution made provision for the regional tribunals, which were entrenched, and it made provision for other tribunals, circuit and community tribunals, which were not entrenched. So even the influence of the Fourth Republic is drawn from AFRC and PNDC, both headed by the same person, which itself drew inspiration from Achampo much earlier. Recently, there's been the Tribunals Bill. The bill has not been passed into law, but it is out there, and I may project a slide on it. But suffice it to say that the fifth dimension over the 150 years is how our judicial architecture has been influenced by the military and the revolutionary favor, and it has manifested itself into the Fourth Republican Constitution and the proposals recently to reintroduce that. Then, these are all slides about some of the legislation that pertain to the military, tribunals, armed forces, acts and its amendments, the subversion decree and its amendments and the like. After we've got the influence of the military, as we have said, there had been attempts in about 2002 to neutralize it. As I said, the 1992 Constitution made the regional tribunals entrenched, so it was there, nothing was done, but the other ones were roped into the mainstream. So it was an attempt to neutralize the military and revolutionary courts. But as I said a couple of months ago, we've seen the Tribunals Bill, and whether it will be significantly modified and whether it will be passed is left to time. How it will manifest itself, we do not know. Suffice it to say, 6 periods mark what we have done over the period. Let me endeavor to be winding down by making just a few observations. One, simultaneous transcription of court proceedings. A justice system cannot operate effectively and fully when what transpires is not readily available. Sometimes, when it comes much later, there are questions about the integrity of the documentation. Sometimes, even for the purposes of considering whether to apply for an appeal or for a review, if you don't have the processes before you, justice is impaired. It doesn't take too much. Last week, there was a juris confab over here, and I was extremely impressed when a member of the planning committee then, Justice Alifo, was making some remarks, and he touched very briefly on something that one or two of the previous speakers had said. He could record, and from his phone or tablet, it was transcribed. So even though there were short excerpts, he was able to do that. And for a judiciary 150 years old, not to currently have the facility for all of its courts at all of its levels. And when the automation of high courts was taking place, there was pride in describing some of them as automated high courts as opposed to others that were not automated. And for that process to effectively take place also in the commercial courts and others. I'm looking at it from the bottom to the top. It is a plea and a prayer that it does not take much, it does not cost much, the technology is currently available, and every court should have the facility for simultaneous transcription. Second, causes and cases should be scheduled. You know when you are going to court. You know what time your court is going to be called. We know what time has been allocated to you, and you go and you do your business and you leave. Justice is delayed unduly. I've reached a certain level of seniority. It doesn't affect me adversely. It doesn't. I've been out of the law school. This year will be 40 years. So it does not affect me adversely. But it will affect the younger ones. You come to court, you are sent by your senior, then the seniors also come before, and then they get their cases called. But the interest of justice is not dependent on the seniority of counsel. The interest of justice is served when anyone who has their day in court is heard at the appointed day and time. And it is no disrespect to seniority if we can consider this. The third recommendation is to pray that reasons always accompany judgment. You thought about something. You considered the evidence. You considered the law. You had a certain basis to make the decree or order you made. State it. If not, it creates the opportunity of post facto rationalization. If there is a reason why it cannot be given, it is better that at the close of argument, a date is set for judgment to be delivered. You go and consider and come and deliver. Or you are not ready, you have a nice way of apologizing or explaining, and you set a new date. But at the time judgment is given, it beats me to think that it was given without a thought for reasons. And if it were given with thought for reasons, then you should spare the time to give the reasons. I've been a law teacher for a while. A typical law question can be a proposition will be put forth, and then they will ask you, do you agree? Do you agree does not mean you say, yes, I agree, or no, you agree. You don't agree. Or you write, yes, I agree. And then next semester, I will give you the reasons why I stated why I agree. So it's not too difficult to do. It best serves the convenience of justice. And my final recommendation, based upon observations that have taken place, is that a judicial council should be transitioning to a judicial commission. It's an experience with other jurisdictions. It's an experience which has served them well. It is an experience where that transition takes place. Everything about the bench, from its recruitment, through progression, promotion, through discipline, and the like, will be handled by an independent commission. Kenya has done it, for example. We can look at it and tweak it. Canada has done it, for example. We can look at it and tweak it. But we should get to the stage where even the concern that people may have as to what to do to be appointed or to be promoted, whether there's a rational, objective basis for it. Is it that you are not in the favor of His Excellency the President, or you are not in the favor of His Lordship the Chief Justice? So whether your name will even be put for consideration tends to be a matter that is problematic, and a system that encourages people to remain, but to be bitter, is more dangerous than a system that purges them. I'm not recommending a purge, but if you have peeved, unhappy magistrates and circuit court judges and high court judges and court of appeal judges who think they should have been promoted and don't know why they have not been promoted, and know that others have been promoted and don't know why they have not been promoted, they will be there. They will be paid. They will do the work. But it does not serve the interest of justice. I have selected only these four because these don't require much expense. They don't require much effort. They only require a will and a resolve that as we define the future, we will make changes to the way our systems have operated over the last 150 years. Over the last 150 years, excluding the assessors before them, excluding the chief justices before them, we have had 28. Number 1, Chambers. Number 28, Paul Bafo-Bonny, and 26 in between. This 2026 is easy to remember. It's 26, then 1 plus 1. So we have got our 28 chief justices. We've listed on this slide the first 10. On the next slide, the second 10. From 13 onward, it came in-house. And on the final slide, the last 8. Let me summarize what we have done thus far, and then I will put out my concluding remarks. Perhaps even my preliminary comments may very well be the most important. We are celebrating 150 years of the Supreme Court ordinance, but we are not necessarily celebrating 150 years of the establishment of court systems in this country. The court systems preceded the Supreme Court ordinance by a significant margin. And even for that thing called Supreme Court ordinance, there was one such ordinance in 1853. There are other points that we have made, but this celebration includes Sierra Leone and Nigeria, and of course, as part of British West Africa, we bring in our Gambians. We have tried to discuss how the 150 years has gone, and we can see that at every stage, without necessarily mentioning names, I didn't want it to be biographical, Cape Coast has featured prominently in it. Over the 150 years, we have had the periods when colonial courts were entrenched. Some of those courts were there already, dealing with petty crimes and debt collectors and so on and so forth. But there was a period when the colonial courts were entrenched. We have looked at how decisions have been appealed to fora abroad. We have looked at the operation of customary law, the operation of native courts, and the operation of the chieftaincy tribunals. We have come to the early 60s when the decolonization of our judicial structure took place, particularly under Osagyefo. We have looked at the influence of the military and the revolutionary dispensation on our judicial structure then and even now in the Fourth Republic, including the discussion about whether to bring back the tribunal system. And finally, in respect of the last point, we have looked at how in 2002 there was the idea to neutralize the influence by not populating the original tribunal, which is in the Constitution, and decommissioning the circuit and community tribunals, because those ones were taken care of by Courts Act. "150 years, we've come a long way. We have seen a lot. We have done a lot. We have seen instances where we could be proud of ourselves as a country. We have seen instances where we have bowed our heads in shame for what has happened. Classical example will be the matters of justice, but beyond that. There's been a period of continuity, there's been a period of change, and as we move forward, it is in our hands to shape the future. We look back to honor it in candor. We look back to celebrate it in sobriety. And we look forward to shape it with conviction. Let us remember that as we are doing all of these things, we celebrate, we define, we honor. The English have been a part of our story. The Gambians, the Nigerians, and the Sierra Leoneans have been a part of our story. It's a matter of the bench. The bar has been a part of the story. The administration of justice has affected all and sundry in the jurisdiction. It is a collective responsibility. Justice emanates from us. I thank the good Lord himself for how far he has brought Ghana. I thank him that he has given us the opportunity to look back, to assess today, and to look forward. And I pray that we will do something about this with the challenge we have received. And thank you also for your attention. And God bless our homeland, Ghana, and make our nation great and strong.
By the lecture he has given us. In a gathering like this, there are some dignitaries who make this occasion very important, and there is always the need for us to acknowledge them. We have our chairman for the program, that is the owner of this school, the Vice Chancellor of the University of Cape Coast, Professor Dennis Olayo Aheto. We will also acknowledge the presence of the President of the Supreme Court, who is also the representative of the Chief Justice, Justice Gabriel Scott Puaman, Supreme Court. We also have some other justices of the Supreme Court of the Republic of Ghana. Her Ladyship, Professor Henrietta Mensah Bonsu. She's with us. We also have His Lordship Kwame Adibu Asedu of the Supreme Court. He's also here. We also have His Lordship Yao Dako Asari He's also with us. We also have His Lordship Ernest Yao Gaiu of the Supreme Court. We also have His Lordship Richard A.J. Frimpong, who happens to be the chairperson of the planning committee of this anniversary. So we have a full bench of the Supreme Court in front of us here. We are also blessed to have here justices of the Court of Appeal of the Republic of Ghana. And they are led by His Lordship Anthony Opon, who happens to be the president of the Court of Appeal. We also have Her Ladyship Angelina Mensah Homia, Justice of the Court of Appeal. We also have Her Ladyship Jennifer Dodu of the Court of Appeal. We have His Lordship Jerome Noble Nkrumah, Justice of the Court of Appeal, with us. We also have His Lordship Samuel Obin Diewu of the Court of Appeal with us. We also have His Lordship Stephen Opon of the Court of Appeal. He's also with us today. Let's also acknowledge the presence of His Lordship Dr. Ernest Owusu-Dapaah, who taught me company law at KNUST. We also have His Lordship Barima Kodie Opon of the Court of Appeal. And we also have Her Ladyship Olivia Obin Owusu, who happens to be the president of the Association of Magistrates and Justices. And she's one of the judges that I encountered when I came to the bar, and I was very delighted. Yes, when I came to the bar, she was in Cape Coast High Court. We also have justices of the High Court, and I will acknowledge the presence of the Supervising High Court Judge of Cape Coast, Her Ladyship Justice Juliana Amonu Neza. And all justices of the High Court present, we acknowledge your presence. We also acknowledge the presence of all judges of the Circuit Court as well as the District Court of the Republic of Ghana. Now, we have eminent traditional rulers, and they are heavy supporters. And it is my singular honor to also introduce the Paramount Chief of Cape Coast, Oguamahin Osabarima Dr. Kwesi Atta II. He is the Paramount Chief of Ogua Traditional Area. And we also have the Paramount Chief of the big city where I was born, Mankesim. Osajefo Amanfu Edu. He is the Paramount Chief of Mankesim Traditional Area. We also have the president, I call her my own president, of the Ghana Bar Association, in the person of Mrs. Ifwa Gati. She's a member of the Judicial Council of Ghana. We also have the president, the vice president of the Central Region Branch of the Ghana Bar Association, in the person of Professor Kojo Adutufo. Let us also acknowledge the presence of the representative of the Prison Service of Ghana, in the person of DPP Dr. Anthony Dazi. We also have present here the Chief State Attorney, Mr. Vincent Abuaji Ineku, is also here. The Central Regional Director of Legal Aid, Senior John Obi Mensah, is also with us. Let us acknowledge him. In the university, there are other persons who are supporting the Vice Chancellor. We have the Registrar of the University of Cape Coast, Mr. Gideon Abikwe, Esquire, is here. And the Provost of College of Humanities and Legal Studies, Professor Daniel Ejapon, he's also here. And I'm told the head of legal, Mr. Solomon Fachi Esquire, he's also present with us. Let us also acknowledge each and everyone that for some reason, for the reason of time, I may not have mentioned your name. Everyone is fully acknowledged. Without your presence, we don't think today's program would have become successful. God bless you all.
Respectfully, the current head of legal at UCC is also a Solomon, but he is Jesse. Solomon, Jesse, please don't issue any writ in respect of this error. We apologize for that. Now, we specifically left out the clergy because they would specially be acknowledged by Ms. Jane Williams, who is going to do the vote of thanks. Shall we appreciate it?
Thank you very much. Mr. Chairman, I respectfully ask that I stand on the protocols that have been duly observed and give the vote of thanks. As we draw this historic occasion to a close, I count it a singular privilege to deliver the vote of thanks. Today has been far more than a ceremonial gathering, and we will all attest to that. It has been a thoughtful reflection of our legal heritage and a powerful reminder that the story of Ghana's judiciary cannot be told without acknowledging the invaluable contribution of Cape Coast to the making of Ghana's legal architecture. Our deepest appreciation goes first to our distinguished guest speaker, my very own Professor Ebo Bonzi Simpson. It was a privilege for me to work as a secretary in 2015, and not for once will he reprimand you if you do something wrong. He will smile, give you a lot of fans. And he has given an illuminating lecture that challenges our minds, enriches our understanding, and reminds us that history is not merely remembered, it is to guide the future. Thank you very much, Prof. I've steered today's proceedings. We are exceedingly grateful, sir. Respectfully, I acknowledge our justices of the Superior Courts, our lords and ladies of the bench, Nananum, the Honorable Minister, members of the Ghana Bar Association, members of the Judicial Service, leadership. Your presence has elevated this program and demonstrates hard work behind the scenes, ensure that today's program was executed with excellence. Though your efforts may not always be visible, they are deeply appreciated. As we commemorate 150 years of the Supreme Court, may we live here inspired by the sacrifices of those who came before us, encouraged by the achievements of the present, and committed to shaping an even stronger and more accessible system of justice for generations yet unborn. Kindly permit me to conclude with the timeless words of one of my mentors, as may we also uphold ourselves in the confidence that the people of Ghana place in our courts and in the administration of justice. May God bless us. May God bless the Supreme Court of Ghana, the Judicial Service, the Republic of Ghana.
Kindly invite to
Jeffo Amanfo Edu, the members of the University of Cape Coast community, the Central Regional Bar President, Nananom, the clergy, members of the bar, distinguished invited guests, other faculty members, staff, and students, the media, ladies and gentlemen. Good afternoon to you all once again. Good afternoon to you all. This occasion, my heart nearly missed the beat. We'll come and calls. So the registrar who is we need them more than they need us. But coming here, I'm extremely excited that I participate. A very meaningful and bear in mind that I need to summarize it in a very concise way to the best of most of us who are non-lawyers as well. Professor, I wish to extend my sincere appreciation to you for the depth, clarity, and historical richness of your lecture on Cape Coast in the making of Ghana's legal architecture, or Ghana in the making of Ghana's legal architecture. You did touch the three key thematic areas of the presentation: celebrating the past, celebrating the present, and defining the future. In celebrating the past, you have made it clear to us that the very foundation of the Supreme Court was laid by jurists who, in moments of national uncertainties, including the incoming of the military regime and all that, chose constitution over convenience, chose precedents over populism, chose principles over pressure. And that, in a sense, has reminded us that the Supreme Court did not emerge from a vacuum. The Supreme Court has been shaped by places, by people, by ideas, by institutions, including the chieftaincy and the native courts. They have also been shaped by struggles. They have been shaped by traditions and historical circumstances, of which Cape Coast has played a significant role in this dispensation, in Ghana's legal and institutional development, of which we are very proud. And today's lecture has helped us to appreciate that contribution of Cape Coast more fully. In celebrating the present, you have assisted us in celebrating the present and enlightening us on the fact that the Supreme Court serves as the final, in as much as it serves as the final arbiter, guardian of fundamental human rights. It has also played a key role as a steady compass in our democracy. The rigor of your arguments, the depth of scholarship that you displayed has rekindled our interest in how justice administered by the Supreme Court over the period has essentially made us to understand the Supreme Court better. We've appreciated the dynamism with which and has earned our confidence as a nation. In defining the future, to base on innovation, be forward-looking technology, and so on, the advent of technology. That's called the fact that as part of the Supreme Court's 150 anniversary lecture series, today's gathering has served its purpose very well. It has enabled us to honor the past with gratitude, celebrate the present with humility, and think about the future with seriousness. The Supreme Court's 150th year journey is a national history, is a national story. A story of justice, constitutionalism, legal professionalism, institutional growth, and continuing responsibility. I also wish to thank all those who made significant remarks during this program, including the representatives of the bar, representative of the Honorable Chief Justice, and Ananom, Father Osabre Makwesiata. We are equally grateful for the cultural performances by our young students from Edinaman and Wesley Girls High School, and all other students' contributions which has embedded this ceremony with color, dignity, and meaning to this event. I wish to commend the Judicial Service of Ghana for choosing the University of Cape Coast for this very important historic event. The Supreme Court at 150 Planning Committee, the University of Cape Coast, and all supporting institutions and individuals for the excellent organization of this lecture. As we leave this auditorium, on my own behalf and on behalf of the Governing Council of the University of Cape Coast, I wish to say that these discussions that we've had today, particularly from the eminent keynote speaker, travel beyond the walls of this hall. May it find expression in judgments Supreme Court 150 years. On that note, Ghana, thank you.
From quill and parchment to digital transcription, in between 150 enduring years of the life of the Supreme Court. But there is a small twist to it. In the second week of November, is celebrating 150 years of the Supreme Court. But in order to avoid being cited for contempt, FANSPIM has shifted it to November in honor of the Judicial Service. On this note, we of the Anglican Church in Cape Coast, Right Reverend Dr. Victor Atabafo to give us the closing prayer.
One word I miss the Lord since I finished my term serving as. Respectfully, my Lord Poaman, President of the Supreme Court, shall we pray? Let's please rise. Gracious and Almighty God, we give you heartfelt thanks for the blessings of this day. We are grateful for the rich reflections we have shared, the wisdom imparted, and the spirit of fellowship that have the Supreme Court of Ghana. We thank you for sustaining this great institution through the generations and for all those whose integrity, wisdom, and faithful service have strengthened the administration of justice in our nation. As we honor the past, grant us the vision and courage to shape a future founded upon truth, fairness, compassion, and the rule of law. God, we pray for the Chief Justice, justices of the Supreme Court, all members of the judiciary, the legal profession, and every public servant entrusted with the administration of justice, and the Constitution, and to safeguard the integrity and rights of every citizen. Bless our nation, Ghana. May peace prevail within our borders, righteousness judge our leaders, and justice flourish in every community. May we all be inspired to contribute to a society where truth is honored, the vulnerable are protected, and the common good. As we depart from this place, strengthen our resolve to build a nation governed by justice, equity, and peace. And now, may the Lord bless you and keep you. May the Lord make his face to shine upon you and be gracious unto you. May the Lord lift up the light of his countenance upon you and give you peace. And the blessing of God Almighty, the Father, the Son, and the Holy Spirit be with you, bless you, preserve you, and remain with you always. Amen. If there's my brothers and sisters who are Muslims here, Assalamu alaikum.
Please kindly remain seated whilst we take photographs. We need to keep memory of the event. Yes. And we will do it here. The order of photography will be as follows. The justices of the Supreme Court